Okay, so in this video, we're going to talk about the 3 cases from week 4, starting on 268 with the Desrochers case. So this is a case involving what constitutes irreconcilable differences. It's not so much about mutual consent. We're going to get to that in the next case, which is a little bit more complicated. And so this is a case where we're trying to figure out, it's 1975. So if you think about that, it's a long time ago. I was not even born yet, and divorce laws changed a whole lot. So take this as a bit of a historical case. But what the Desrochers case does is it shows us that whether the marriage is irretrievably broken is a finding for the trial court. Now, most of the time, statutes have changed, and we'll see a statute change in just a second, that don't necessarily require a finding of fact, but just an allegation under oath of one of the parties. But the statute in Desrochers required a finding of that the marriage had been irretrievably broken. In the cases in this book, the first 2 involve situations where one party, in both cases the wife, wanted a divorce and the husband did not. So in the Desrochers case, the wife wanted a divorce because the defendant, the husband, didn't work. When she was pregnant, he wanted a boy, and if she had a girl, which she did, he wanted it put up for adoption, but then became attached to the child after a period of time. Then after the wife filed for divorce, he started kind of showing up more, paying his $25 a week child support for the kid, and then no longer wanted a divorce. And so the court in Desrochers made a factual determination, or actually it didn't. The trial court said, we don't know if there's enough facts to determine for us whether or not that it's irretrievably broken, because the statute didn't really say, did both parties have to agree? It was 1975, so they were still trying to figure out what no fault meant, and they kicked that issue up to an appellate court. And the appellate court said this: that is up to you to decide. There's enough evidence in the record for you to decide that. But that is a determination for the trial court. So we have this sort of conflicting evidence. She says it's irretrievably broken. He says that it's not. The appellate court said, we're going to kick it back to the trial court for you to make that determination on the record. Meanwhile, since the husband started appealing, his legal situation deteriorated, because after the appeal was argued, he stopped making support payments and moved away to Nevada from New Hampshire, almost across the entire country. So by that point, there was less in the record after appeal when they remanded it back for them to come back and say it's not irretrievably broken. So that's ultimately the logical outcome of this case on appeal. I haven't confirmed it, but that's what makes sense, right? Let's contrast this with page 270 with the 2010 New York divorce statute, which does not talk about the trial court making a determination. But it says, if one party has stated under oath that the relationship is broken down irretrievably, that's enough. So it is no longer, and that's what most states are going to, right? Most states are going to, if one party asserts it, the court is not going to have this fact-finding journey as to whether or not the court can make that determination better than the parties can, because essentially that's what's happening, right? Is that one party is saying, I want a divorce. The other one is saying, I don't. And the judge in Desrochers has the power to say, you know what? No, I think you should stay married. I think y'all can work it out. That is not typical for today. In 1975, obviously, they were just kind of easing out of fault-based divorce into no-fault divorce, and it was that trial court. We're not doing that anymore. Again, your mileage may vary. Take a look at your own statutes. So let's talk about Flanagan versus Flanagan on page 271. This is an interesting case. A second marriage for both of them. They're in their 60s. And wife has filed for divorce. She says husband's a drunk, and he is having some intimacy issues and decides to fix them via the internet and buying a bucket of clams and some beers for another couple that he ultimately, well, you can read the facts on page 272. But wife has said, I did not expect to live out my senior years with a drunk philanderer. I would like to get divorced. Husband says he does not want to get divorced. And so the question it revolves around the Maryland statute, because the Maryland statute on 273 had 3 different grounds that the court talked about for divorce. One was desertion. Spouse takes off, leaves, or leaves the marriage, deserts the marriage. Talk about that in a second. Number 2, voluntary separation. Now, the text of the statute in Maryland did not say mutually voluntary separation, but the case law by the time Flanagan was decided did. And so the case law in Aronson versus Aronson and another case that the Wallace that the court talked about had read mutually into voluntary. Why? That makes sense. Because if it isn't mutual, then what's the difference between that and desertion? If there's a separation, there wouldn't be any difference. And so the court very specifically read into voluntary separation this mutual consent. And so this is what we're talking about. And so in the other video I did, talked about the fact that some statutes will change time periods or other things based on whether or not both parties want the divorce. In this case, the trial court had granted the divorce based on this voluntary separation. And the appellate court said, well, that's not right, because we have read in previous case law mutual into that voluntary separation. And the husband all along had said, this is not a mutual separation. I don't want to get divorced. The court, though, said on appeal, this was harmless error because he deserted her, essentially. And the court said that there's multiple bases, right? We have fault-based, which was desertion. Voluntary separation, which was not desertion, it was no fault. And then there was another one. If you can be separate for 2 years, regardless of mutual consent, you can be divorced. And so we hadn't been to that point at the time that it was on appeal. But the court said, we are also going to read into desertion constructive desertion, or our case law is going to reflect that constructive desertion counts for desertion under this statute. Now, again, this is a 2008 case? Yeah, it's 2008 case. Historically, constructive desertion wouldn't have cut it for fault-based divorce, but in this particular case, it did, because the court said he constructively deserted, sorry, it's my big dog up here. He constructively deserted the marriage when, and I'm going to read this for you. When he engaged in such conduct as would make a continuance of the marital relationship inconsistent with the health, self-respect, and reasonable comfort of the other, so demeaning to his or her self-respect as to be intolerable. And the court said that is constructive desertion. And based on the drunkenness and based on the conduct of the husband, the court said, especially considering there was evidence of him acting inappropriately with other women, that years of her husband soliciting extramarital sexual relationships on the internet, heavy drinking, and verbal abuse, the court said that is constructive desertion. So they found fault enough to dissolve that marriage. Now, that Maryland statute has since changed. I talked about in the other video. The time frame has changed to 12 months max, not 2 years. Okay. Third case, saddest case on the planet. This is where elder law, estate law, disability SSI law come into play with overlap with family law. This is an incredibly sad case. Vandervoort versus Vandervoort. I don't know how old these people are, but it makes me think that they're fairly young and the wife was sick. And they got divorced. Wife and husband got divorced because she was sick and they saw that she would need care in a care home and she wouldn't qualify for it if all of their joint assets were taken in consideration. So they got divorced. She gave him most of the assets so that she could qualify for public assistance. She then, at some point, went on to live with her parents, which makes me think that she was obviously young enough that her parents are still alive, which in my mind it's sad when it happens to anybody, but you don't anticipate being young and having to be in a situation to divorce your spouse so that you can get the medical care that you need, right? This happens all the time. I'm sure you've seen cases like this fairly recently where, in fact, I've seen one very recently. I'll see if I can post the site for you in the class, where the husband and wife had to divorce because she needed care and they couldn't. She couldn't get it based on his income, I think. And then once they got divorced, they had to live apart because of essentially what's going on in Van de Voort versus Van de Voort. So she leaves. They get divorced. I'm sorry, they get divorced, but they don't ever stop living together. And he eventually, she says she went to visit her parents and the husband refused to allow her to return. So they get divorced for purposes of benefits. They are still living together at some point. She goes to visit her parents. He says, you can't come back. She files to essentially undo the marriage because she's making the argument that we agreed to do this so that I could get the support, and now he's not supporting me. The court said this divorce was concocted. It offends public policy to use such a divorce for financial gain. Rather than leave the parties where we find them, we believe equity and justice require that they be returned to the state of matrimony. That is 2005. So this is what we're talking about when we talk about collusion. We talked about collusion relative to fault-based divorce. Parties, if they wanted a divorce, but mutual consent was not a basis years ago, could collude and say, well, let's agree that you were cheating on me, and so we can just go to court and get a divorce. That's collusion in a fault-based divorce. This is essentially collusion in a no-fault divorce. They didn't want to be divorced. They wanted to be together. But them being together made her ineligible for the long-term care that she needed to survive. And then when things broke down between them, she said, we only got divorced to take advantage of public benefits, so I think we should be married again. And the court, in that case, agreed with her. This is one of those situations where you can look at this case and decide for yourself whether you think it's right or wrong. I don't think there's a good answer. Is the good answer what the court did, forcing them to be married again? I don't know, because now at this point, the husband doesn't want to be married anymore or doesn't want to be in this non-married marriage with her anymore. But she now needs it because she's given up all of her assets to him to avoid having them count against her in terms of her care. So do we force him to stay married? Or do we force her to not get the care she needs because she has given up her assets thinking that she could get public benefits as a result? In the real world, her public benefits can be, and I don't know too much about the system, but there are ways that you can not qualify. And the example I gave you a minute ago about the couple that couldn't live together because it was essentially collusion, that's a problem as well. So there aren't really good answers. It's a sad situation, but that's what those three cases are about. Hopefully that helped. And if I can find that case with those people, I will post it to the class. Take care. Email me as always with any questions.